Hi, it's Mike Delsignore. I'm here outside Malden District Court. I want to talk about what happens if you're charged with a second offense, OUI. Well, if you're charged with a second offense, there's some key things I want people to understand. That the license loss is different depending on how far apart your two OUI offenses are. So let's say your OUIs are more than 10 years apart, then you're in a different situation. You're looking at potentially a shorter license loss if you resolve it, or even if you're found guilty after trial. So there's a big difference between whether your offenses are 10 years apart or more than 10 years apart. Let's say offenses are within 10 years, then you're looking at a pure second offense where if you refuse the breath test, there'll be a 3-year suspension. You wouldn't be eligible for hardship on that 3-year suspension. So you'd want to fight the refusal suspension. Here's how you do that. You either go to the RMV in Boston and have the suspension overturned, or you have to win the case in court. Whereas if your offenses are more than 10 years apart, then even if you refuse the breath test, there's a way you can resolve the case, potentially get back on the road as long as you get the interlock device in your car. It's called the Cahill resolution of the case. So understand that there's a major difference between the offenses, whether they're within 10 years or outside of 10 years. But what are the other key points to know when you're arrested for a second offense OUI? In many cases, your best option is to fight these cases. Judges often won't penalize you for going to trial. In many cases, your penalty after trial will be similar to what you have got if you taken a plea. These cases are very winnable. They're based on opinion. Opinions can be wrong. We know that from our everyday life, that people can be mistaken and officers can be mistaken just as anybody else. When they assume that somebody can't do a field sobriety test because of alcohol, it could have been because they were nervous. It could have been because they were tired. It could have been because they just don't have good balance, and we can present that with medical proof and medical records. I'd like to show the jury as much as I can. We have no burden of proof. As a defendant in the case, the complete burden of proof is on the government. It's a high standard. They got to prove the case beyond a reasonable doubt. I like to present as much as we can that's helpful to the case. We'll present your medical records. We'll present any information that shows that gives the jury more information to show that you weren't under the influence of alcohol when the officer stopped you. Keep in mind that standard. It's a very high standard to prove something beyond a reasonable doubt to a moral certainty. And that's why these are very winnable cases. Even if you took a breath test, those results can often get excluded from evidence. So it's not determined that those test results are going to come into evidence. So if you have a question about an OUI second offense, I've handled these all the time for people, can help you get your license back and get you back on the road and give you the guidance you need to make sure you make the right decision for your case. My name's Mike Delsignore. This is what I do for my job. Help people in difficult situations, and it's our passion, and it gives us a great privilege to stand up for somebody in court that can't stand up for themselves. And you're in a difficult spot, but I'm here by your side to help you. So you can call me, 781-686-5924. Call, text anytime.